Good morning, everyone, and welcome. My name is Sophia Sepp, and I'm the program manager with the Center on Immigration and Child Welfare, and we're excited to be here today to discuss supporting the legal needs of immigrant children in foster care. We recently conducted a joint webinar with the Foster Club's Youth and Alumni Policy Council to dive into their priority statement on supporting immigrant youth in foster care. And we found that many participants had questions about supporting immigrant youth's legal needs, especially around special immigrant juvenile status. So we're hoping that today's webinar helps provide some important context and recommendations for best practices around those topics. This webinar is hosted by the Center on Immigration and Child Welfare, which is a national peer membership organization housed in the School of Social Work at New Mexico State University. We work to improve programs and policies related to immigrant children and families involved in the public child welfare system via original research, resource development and dissemination, training and technical assistance, and national leadership that promotes cross-sector collaboration among professionals across the child welfare, immigration, and legal fields. For more information about our mission and work, you can visit our website at www.cimmcw.org. You can also find us on social media, on Facebook, Twitter, and Instagram. And then you can sign up for our monthly e-newsletters for the latest updates on practice, policy, and research resources on immigration and child welfare issues. We're very excited today to welcome our featured speaker, Randi Mandelbaum. She's the founder and director of the Child Advocacy Clinic at Rutgers Law School. The CAC provides representation to foster children, undocumented immigrant children, and low-income children with disabilities, and specifically partners with the New Jersey Department of Children and Families to provide immigration legal services to children in foster care, which we'll hear more about today. We're also very grateful to have several other experts from the child welfare and legal fields from across the country join us today, including representatives from the ABA Center on Children in the Law, Casey Family Programs, and the Immigrant Legal Resource Center, as well as from the immigration units and child welfare agencies in New Jersey, Los Angeles, California, New York City, and New Mexico. And we look forward to hearing from them a little bit later. So here's a brief roadmap of the topics we'll be covering today. Randi will take us through SIJ basics and common challenges, why a fact-finding order is not sufficient, child welfare legal obligations, obligations to provide legal representation, and recommended legal screenings and representation. Then we'll hear from Christina Cooper from the ABA Center on Children in the Law and Rachel Conrad with Casey Family Programs about a sample screening tool they've developed that can be used by child welfare caseworkers and attorneys to screen immigrant children and youth for legal relief. And for the last part of the webinar, we will be hearing about some of the best practice models for supporting the legal needs of child welfare involved immigrant youth from New Jersey, California, New York City, and New Mexico. A brief housekeeping note, please share any questions that come up during the webinar via the Q&A function, and we will do our best to address them during the Q&A period at the end of the webinar. And with that, I'll turn it over to Randi Mandelbaum to get us started on SIJ basics.
Hello, everyone. Thanks for joining us, and thanks to Sophia and CICW for hosting this webinar today. So I'm gonna try to quickly go through what I call what are some of the special immigrant juvenile status basics, and then some challenges, especially with regard to child getting a SIJ order in a child welfare, child protection matter. So first off, what you see on the screen are, is basically the law around special immigrant juvenile status. This is a federal law that was enacted first in 1990 and has been changed several times over the years. I could show you the actual text, but I find it easier to just boil it down to these 6 criteria. So in order to get special immigrant juvenile status, which I'm going to call SIJ for short, the youth must be under 21, not married, physically in the United States. And the last 3 I'm going to go into in depth in a couple minutes, but I'll just say them now. dependent upon a juvenile or family court, or needs the attention of that court to have somebody grant custody over the youth, that reunification with one or both parents is not viable due to abuse, neglect, abandonment, or something similar under state law, and that it's not in the youth's best interest to return to a country of origin. And essentially, and especially for the last three, we need, you can go to the next slide. We need a state court, a state family or juvenile court, to make these determinations, what we call factual determinations, and put them in the form of an order, what a lot of attorneys and advocates call a predicate order, because you must have that order in order for the youth to apply for SIDGE. And it is essentially a three-step process. So first off, you have to get that state court order, which we're going to spend a little bit of time today talking about. Then you have to send in that order to the USCIS, the U.S. Citizenship and Immigration Services, and you send that in with a form that's called the I-360, and with the child's birth certificate that has to be translated into English, because you need to show proof of their date of birth. And then if that gets granted, that will allow the child to eventually apply for lawful permanent resident status, or their green card, which is done through what's called an I-485. The second step is supposed to take 6 months under federal law. That's the requirement. That is not always complied with, but that is the law. Next slide. So first off, it's important that once to know that once SIDGE is approved, that doesn't mean the child gets a green card, right? They're going to then have to apply for the green card. Next slide. And there's a really big wait, because I could spend a long time talking about it, but there's essentially a backlog. And the backlog has changed a bit over the years. It first involved only children from the Northern Triangle countries and Mexico, and then that changed about 8 months ago, and now it applies to all children. So essentially, once you get that state court order and apply for SIDGE and get approved for SIDGE, the children or the youth have to wait in order for a visa to become available so that they can apply for their green card, for lawful permanent resident status. And that wait, give or take, is about 5 years, which is really troubling. And there are efforts going on to try to fix this visa problem, but at the moment, this is the current state of affairs. Next slide. The good thing is that, and this is a relatively recent change in SIDGE policy, that once the child is found eligible for SIDGE, what comes with that is two things. One is that they are eligible for up to 4 years of deferred action. And this is most youth. There may be youth that don't get this, but most youth will be eligible for up to 4 years of deferred action, which means for 4 years, the government is saying, we will not seek to remove this child unless something changes. And that grant of deferred action allows the child to apply for work authorization. And along with the work permit will come a social security number. So at least while the child is waiting those 4 to 5 years to be able to apply for their green card, they will have the deferred action and they will be able to apply for a work permit. Next slide, please. So turning now back to the state court process and getting that very important state court order. So first, it's important to know that these orders can be obtained in a variety of state court proceedings. The two highlighted are the ones that would be relevant to a child welfare case, a child protection, or sometimes called a dependency hearing, and a termination of parental rights proceedings if it goes into, if after a year or more, the state agency or the local agency is seeking to do a TPR. But it also could be obtained in an adoption proceeding, a custody or guardianship, a probate, and even a juvenile justice or delinquency case. Essentially, any state court proceeding where the court has the authority to grant custody of the child to someone or to an agency is a proceeding that the predicate order could be granted. Next slide. And I just really want to stress, because I think this is often overlooked, that it can be in a juvenile proceeding, in a juvenile delinquency proceeding. So long as the judge has authority to make determinations on dependency or custody, the SIDG determinations can be made. It's best to do it before or at the same time as the judge is making their dispositional orders. But I have also seen it done if you get a case and it's post disposition, you can still try to make the request for the predicate order in a post disposition request or motion. Next slide. And these on this slide, and I'm hoping the slides will be available after, but is really just support for what I just said in terms of getting SIDG in a juvenile proceeding. Next slide. So now I want to go back to those 6 criteria that I started off with, and I want to go to the third one, which says that a child must be dependent on a juvenile court or legally committed to or placed under the custody of an agency or department of the state or an individual. So really, just to be clear here, if the court is finding this child dependent and placing them in the custody of a child welfare agency, that would qualify. If the court is even just finding them dependent on the court and making orders that are sought by a child welfare agency, that would be fine. I also do some work where I'm not involved with child welfare agencies, but a child is placed, let's say, with an aunt, and I might go into court and seek custody to that aunt and ask the court to also make the SIJS factual determinations. So really, just again, any case where the court is either finding the child dependent or making a custody order, that will qualify. But you want to make sure that in your predicate order, the court is saying they're making this custodial decision or finding the child dependent. Next slide. So the next criteria is that the court needs to find that reunification is not viable due to abuse, neglect, abandonment, or something similar under state law. I'm going to cover the similar basis in a moment. But here, this is going to vary from state to state because every state's definition of an abused or neglected child will vary. What I have here is a shortened version of New Jersey's definition, but every state has this in their family law code, and you really just need to look to the state's definition of abuse or neglect and abandonment. The federal government is very clear that they want to be looking to state law. Next slide. Also important, and this comes up quite frequently in child protection matters, the abuse, neglect, or abandonment, or something similar, can occur in the US, or it can have occurred in the home country. And now the child is here, but it would be unsafe for the child to return. And sometimes, because sometimes what happens is that the abuse, neglect, or abandonment that is before the family or juvenile court in the US may be about something that has occurred here. And the court may be trying to reunify with that parent. But if you can show that the other parent, and who may still be in the home country, also abused, neglected, or abandoned, that might be the basis of finding that it wouldn't be possible to reunify, even with the parent that the child may have been removed from. So, for example, let me just make that a little clearer. You know, if the court now has a case because there are allegations of physical abuse by the mother against the child, but they're working toward reunifying that child with the mother, but long ago the father in the home country abandoned that child and hasn't been involved, you can still say that reunification with the father is not viable due to abandonment, while you're saying that the child, you know, that the court is working on reunification with the mother. And I'll explain more in a minute on why that's okay. Next slide. And that is okay because you only need to show that reunification is not viable with at least one parent. And USCIS has been very clear that this is the policy. So, right, court may be working toward reunification with one parent, but if we can show that reunification with the child's other parent is not possible, then that would qualify. Next slide. One thing I really want to highlight, and again, this could be the subject of a larger conversation, but in child welfare matters, the court does at some point make a finding of fact and enter an order showing that the parent or parents may have abused, neglected that child. And I often get asked why that fact-finding order that says here's that abuse or neglect was found is not sufficient to just send that order to USCIS. But it often is not sufficient because that fact-finding order, which may say that find that a parent has been abusive or neglectful, often doesn't say everything that is needed for USCIS purposes. It probably doesn't say that reunification is not viable due to the abuse or neglect. It may not address that it is not in the child's best interest to return to the country of origin. You know, if it's like the hypothetical I just explained, where it was abandonment by the father in the home country, that order probably doesn't even mention that. So really, if possible, it's best to obtain a separate order that very clearly sets out the requirements of USCIS with the magic language that USCIS usually wants and the factual support for that. Next slide. Now, as I mentioned before, you can have abuse, neglect, abandonment, or something similar under state law. So sometimes something looks a lot like abuse, neglect, or abandonment, but it doesn't quite meet the definition, or it meets the definition in terms of what the state requires for that, but it doesn't necessarily use those words. So examples of this are some states have children in need of assistance statutes. New Jersey has that. I think Connecticut has an uncared for child statute, right? Those are statutes that are finding that the child's in need of the state's assistance, that's placing the child in the custody of the state, right? It's showing that the parents can't care, maybe not quite for abuse or neglect, but maybe because the parent has a disability or the child has such needs that the parent can't meet those needs. That qualifies as something similar. Other examples of something similar might be cruelty. So like some states, in addition to having a definition of abuse, have a definition of cruelty, which again would be similar to abuse. Another common scenario is whether the death of a parent might be something similar. Next slide. And in some instances, death can either equal abandonment or be similar to abandonment. You really need to be looking at your state's definition of abandonment. In many states, it doesn't require any kind of intent or willful forsaking, but really just talks about how the child is then left to be cared for by others or something similar. And in those instances, death would really equal abandonment because the outcome of death would be similar to abandonment in that the child is being left to be cared for by others. So what you need to be careful of is making sure that you cite the statute in the predicate order that is the equivalent. And so you make it clear in the predicate order that the parental death does constitute or is legally equivalent to the definition of abandonment. Next slide, please. And so the last criteria, if you remember, is that it's not in the best interest of the child to return to their country of origin. And I find that sometimes this is the criteria that the judges have the most difficulty with because they feel like it's they're being asked to be an immigration judge and not a family court judge, and know what's going on in Ecuador or El Salvador or some other country. And I very much try to explain to the judges that that's not the situation, that they're really just looking to the standards for best interests that are in all of our state laws, and just trying to make a best interest determination about this child as they would any other child. So looking at, where is the child's caregiver? Is there a caregiver in the home country? Where is the child support system? The physical and emotional well-being of the child? Do they have any special needs? Do they need special medical or educational resources? All of the things that the best interest tests that are in state law look to is how the judge should make that determination. Next slide. And one other thing that state court judges sometimes mistake is that the state court judge is not deciding whether the child is eligible for SIDGE. They have no authority to do that. All of this, it's a very interesting and limited role that the state court judge plays in this, an important role too. But they are to render those factual determinations or findings and put them in the form of an order, and that is it. You then send it to USCIS, to the federal government, who will then look at the state court order, the birth certificate, and the application, and determine if the child is eligible for SIDGE. And these determinations are factual findings that the state court judge is supposed to make, is also supposed to be under the state law that the judge is practicing, not the law of the child's country of origin. And again, there have been cases around the country where judges have made this error. Next slide. So just a word of caution as I wrap up. You really want to, as an advocate for the child, be mindful of when the jurisdiction of the court may be ending. In some places it's 18. In some places it may go to 21 or something in between. But you want to make sure that you get that predicate order before the jurisdiction of the court is lost. And just a word of caution is sometimes in some states, the agency may stay involved with the child and provide services and support, but the court intervention, the court oversight might end. There are some states where court ends at 18, even though the agency might continue to serve the child or the family beyond that time. Next slide. So super important, and what we're really going to be talking about for the rest of this webinar is to really try to identify the need for children that may be involved with the child welfare agency, may be in your caseload, who really may need the assistance of an immigration lawyer. So, first off, and I know Rachel and Christina are going to talk more about this, but big red flags of when a client might benefit from legal immigration assistance is no social security number or a social security number that is restricted. Big red flag. Their birth certificate is not from the United States, or they have a passport that is not from the United States. If they're showing you immigration documents or really are unsure about their immigration status, all of these are what I would call big red flags that this child ought to be sent for legal immigration assistance. And really important, that just because a child, might have some temporary status like TPS, temporary protective status, or DACA, doesn't mean that they don't need to seek an attorney. They may still be eligible for another form of immigration relief, like we've been talking about special immigration, juvenile status, maybe asylum, maybe a T visa. So really important to, not just rest on the fact that, oh, this child might have DACA or TPS. Super important that we really try to get all of the children that might be eligible to the point of a green card and then citizenship, and not rest on temporary statuses. Next slide. And I just really want to stress before I turn it over that, it's super important to ensure that children who have immigration issues are represented. The immigration law is among the most complicated type of law that there is, and the issues concerning immigrant children and youth are very complex. And and most of the children that are involved in the child welfare system are eligible for some form of relief, likely SIDGE, but maybe asylum or a T visa as well. And I believe that it is the obligation of child welfare agencies to provide this representation, or to ensure, not to provide it themselves, but to ensure that children are represented. When children are in the custody of a child welfare agency, the state is the parent. And as a parent, the state has that obligation to ensure that the children's immigration status is stabilized. In addition, the agency has the obligation to provide permanency for children. That is one of the primary principles and goals of the Child Welfare Agency. And no child is going to have permanency if their immigration status is not stabilized when it's able to be. And so it is the obligation of the agencies to, in some way, and we're going to hear about all different ways, ensure that the children are represented by competent attorneys. Next slide. And with
Thank
that,
you, Randy.
I will turn it back over to Sophia.
Yes, thank you, Randy. We're going to pass it over to Christina Cooper and Rachel Conrad now to talk about a legal screening tool that they have developed. Go ahead, Christina.
Yes, Sophia. Rachel and I are happy to be here with you and briefly highlight something that we developed as a first step for agencies and caseworkers in particular to use with youth in their care who they think may need immigration law resources and help. I will just note, I'll turn it over to Rachel to give a speedy overview of what the tool is. But we offer this as something that caseworkers and agencies can tailor to their own jurisdictions. But it includes really just the basic information that you would have in your case file that Randy has already noted in terms of birth certificate, having one or not having one, and US based documents like passports or social security numbers and other things like that. You don't have to do an extensive analysis or conversations with youth to decide that this referral tool would be useful. It's a matter of having that initial suspicion that they perhaps could use, that they don't have status here or they don't have US citizenship and could benefit from immigration legal representation. Rachel?
Thanks, Christina. I know after hearing Randi speak that everybody who doesn't use something like this in their jurisdiction wants to. I wholeheartedly second everything Randi said. She's a really tough act to follow. Christina and I have collaborated to develop kind of a first step, and we have a tool for caseworkers, and we have a separate tool for attorneys. We are going to share them with Sophia, and we'll be distributed out to you after this webinar is over. But what I would really say is that when a child is in care, this is a golden opportunity in some ways. I mean, in some ways, we're meeting a family in the moment of crisis, but a potential silver lining or an opportunity that exists is for us as stakeholders, as caseworkers, children's attorneys, and advocates to stabilize status. And so this tool is meant to guide you as you look through the case file, and it focuses on the birth certificate, whether foreign or missing. It's important to highlight, I think, that a lot of families do live in fear. And so if it's missing, I would encourage you to just refer anyway. I know when I was in direct practice, and I know Randi in direct practice now, would rather just do an immigration check, and then and if there's nothing to be done, thank you for the referral. Immigration attorneys would rather receive too many referrals than have kids out there who have remedies that are not being pursued for them. So just look in the case file, look for a missing or a foreign birth certificate, or any type of information of a non-citizen status. I would say even if a child has temporary protected status or a green card, still make the referral. And the other kind of soft way to identify an immigration need is often educational records or the absence of educational records. So again, Christina and I thought very carefully, and it may be slightly different state to state depending on your confidentiality policies. But currently this tool really just asks you to look in the case file and err on the side of caution when making the referrals. So we'll send this out to you after, and we'd really appreciate feedback. We have gotten some feedback, but this isn't in its quite finalized. I mean, it's finalized as much as we can, but we'd love to know how it's working for you so that we can make adjustments. Thank you for letting us present, and thank you for helping identify the needs of the kids in your jurisdiction to give them security. Back to you, Sophia.
Thanks, Rachel. So now we are going to go into our best practice models section. We're going to hear from panelists in New Jersey, California, New York City, and New Mexico about their models in their jurisdictions for serving immigrant children in the child welfare system and connecting them to legal supports. And I'm going to turn it back over to Randi to talk to us about what they do in New Jersey.
So hi again, everybody. I'm really going to talk for just another minute, and then I'm going to turn it over to our wonderful representative from the New Jersey Department of Children and Families, Georgiana. But back in May of 2016, Rutgers, specifically the clinic that I lead up in Newark, New Jersey, the Child Advocacy Clinic, along with the Immigrant Justice Clinic led by my colleague Joanne Gottesman down in Camden, started a collaboration with the Department of Children and Families of New Jersey to provide immigration legal services to children in foster care or youth aging out of foster care. So now basically, if you are a child in New Jersey's foster care system or aging out of it, and you are in need of an immigration attorney, a referral gets made. And I just want to, state, we started small because, initially there really wasn't a great sense of how many children might need this service. So we started with one full-time attorney, actually 2 half-time split between Newark and Camden, and we agreed to take about 40 cases. And this was, I think by month 4, we were at about 70 cases. Next slide. So Georgiana's going to talk about, what exists now. But I just really want to highlight, why I think, and Georgiana can talk more, that DCF did want to partner with us. And it's some of what I said before in terms of promoting permanency and stability for the child, but it also really does a lot of other things. It allows this child to, if we can apply for a form of immigration relief that permits it, we can get a work permit and the child can work lawfully. It allows them to obtain different forms of public assistance, including health insurance, money, financial aid, federal financial aid for college. New Jersey does also provide some state support for some immigrant children. And it really does alleviate the child's vulnerability, and in some instances really enable the family to remain together. And with that, I'm going to pass it over to Georgiana. And here is my contact information. Should you want to reach me, I welcome any inquiries after today.
Hello, everyone. My name is Georgiana Romero Ochoa, and I am the Immigration Legal Specialist here at DCF, New Jersey's Department of Children and Families. And I will talk to you all a little bit about our project and our partnership with Rutgers that Randi sort of alluded to already this morning. Next slide, please. So the reason why we partnered with Rutgers was because DCF recognized that immigration, as Randi said before, is tied to ensuring permanency and stability for a child. Without a permanent status in the U.S., an immigrant child will have difficulty in achieving independence, working legally, receiving financial aid for college, and just that fear of being in the U.S., right, and possibly being deported is a fear that we would like to remove as well. And prior to the project, our caseworkers did not have a coordinated approach to seek out legal services for immigrant children and other caseloads. So that was something that we were really looking to correct. Next slide, please. So what is the partnership? So as Randi mentioned before, it started back in 2016, and the project is based out of the Rutgers Law School, and there are two main campuses, one in North Jersey and then one in South Jersey. As Randi mentioned before, due to the increased need, we now have, or the project now has 4 attorneys, 1 supervising attorney, 3 staff attorneys, and 1 paralegal. Started with 40 cases, now we have 175 open cases. Priority is given to those cases of children who are aging out of care and those exceptional cases that we mutually agree upon between Rutgers and DCF. Next slide, please. So how are referrals made? So referrals are made between, for children who are in care between 0 to 21, right? So at the time that referral is made to Rutgers, they have to be in our care. How does it work? Well, cases are referred by our staff or caseworker. They fill out the form that was prepared, we collaborated upon between DCF and Rutgers, and then those referrals are routed to the paralegal who receives the case, gathers information, asks questions from the caseworker, and then that case is transferred and assigned to an attorney. Next slide, please. So my role as the immigration specialist, I serve sort of as a liaison between Rutgers and DCF. But in addition to that, I also work with our local offices, conferencing matters that the immigration issues, questions, notifying consulates, and creating those relationships with local consulates as well, just because it comes in handy when, documentations, biographical documents such as birth certificates or travel documents that we're trying to reunify a child in the country with a relative or parent. Also, there's a variety of other things that come along with immigration cases that deal with immigration. So I am here to assist and to provide education to our staff. Just on U visas, T visas, anything like that, any sort of relief that a child may qualify for, and also in filling out the referral. Sometimes they may have questions and documents that I think might be important that Rutgers will need later on. So I make sure that I am assist our staff and all of that. Next slide, please. So here's my contact information. Feel free to reach out if you have any questions.
And if I could just add something, just to know that all the referrals that we get, I'd say the majority of them are undocumented children where we're going to apply for SIJ and maybe even asylum or T visa. But, we also will help with the lost green card or if the child's eligible to naturalize, or, you know, and we also, you know, I think it was Rachel who was talking about the checks. We do checks, and, you know, even on a child that supposedly has a green card. And unfortunately, we have found that in some instances, those green cards are not good, that the adults around the child, in some ways did something fraudulent such that the green card is not what we would call a clean green card. And so we then go back and try to either fix that or, you know, apply for SIDGE or something else. So I can't stress enough about the need to refer and to screen and refer, and then to have, you know, the resources that will allow the child to see that immigration attorney. Some, you know, we might get the call that it's just a good green card, and so that's an easy check and close. But, you know, sometimes it's not the instance. And I will stop. Thanks.
Thanks, Randy. And thank you, Georgiana. We're now going to pivot over to California, and we're going to start with some brief background from Rachel Prandini at the Immigrant Legal Resource Center on some of the policies in California that guide pursuing immigration relief for youth in care.
Hi, everyone. My name is Rachel Prandini. I'm an attorney with the Immigrant Legal Resource Center. And if you're not familiar with our organization, we're a national nonprofit resource center based in San Francisco, but with offices in California, Texas, and Washington, D.C. And we're really a resource center on immigration law and policy. We have done quite a bit of work in California at this intersection of immigration law and our child welfare systems. And so today I've been invited to give just a brief overview of the law and policy guidance that we have in California on supporting young people who are in the child welfare system to be able to pursue immigration relief. And then following my brief overview, you're going to hear from one of our large counties about how they have implemented this guidance. Next slide, please. So dating back to 2012, when California passed the Reuniting Immigrant Families Act, which I believe was the nation's first law addressing the reunification barriers faced by immigrant families who are involved with the child welfare system. So since that time, we have had in our law, in the Welfare Institutions Code, a requirement that for children ages 16 or older, that their case plan has to indicate whether they have an in-progress application pending for special immigrant juvenile status, which we've been discussing today, or any other applicable application for lawful status, like a U visa or a T visa or something along those lines that has been mentioned. And the goal of that requirement is really to ensure that our child welfare agencies are screening for immigration relief options for immigrant children and families, and supporting youth in pursuing those options as part of the case planning process for youth, looking ahead to them transitioning to adulthood. Because as we've been discussing today, and as you heard from Randy and others, lawful immigration status is so critical to being able to successfully transition out of care, for ability to work, for access to federal financial aid, for the emotional, stability that comes from living without deportation, without the fear of deportation, I should say. So we have that requirement, and then more recently, a provision was added to our Welfare Institutions Code to require that when the placing agency becomes aware that a dependent child or a non-minor dependent is undocumented, that it has to notify the child or non-minor dependent's attorney within 5 business days. And that is really to ensure timely screening for immigration relief, and also to ensure that if the young person is eligible for SIJS, that they can begin the work at the earliest point possible to pursue the SIJS predicate order, because as Randy shared, there is a long wait time to actually getting the green card for SIJS, and so the sooner you get started in that process, the better. Next slide, please. Beyond that, our Welfare and Institutions Code as of 2022 requires counties to make best efforts to provide undocumented minor or non-minor dependents in foster care with access to immigration legal services. And it specifies that the access may be provided by outside legal services providers. And indeed, in most California counties, that's how the immigration legal services are provided, by an outside legal service provider, such as a local immigration nonprofit, or perhaps a trusted private immigration attorney. So this does fall short of completely mandating the provision of immigration legal services by the county, unfortunately. But nonetheless, it puts the onus on the county to really make the best efforts to do this. And the hope is that counties will view this as an essential part of caring for children and furthering the best interests of the child. And then the last thing that I want to point out, which is the second box on the screen, is that we also have guidance from our California Department of Social Services through all county letters. And I've highlighted one here. Our all county letters are used to advise counties of state law and policy. And recently, as of last year, we have an all county letter that stresses that identifying a child's immigration status is essential to the minor or non-minor dependent's future, because the caseworker is going to use this information first to notify the minor or non-minor dependent's attorney, and second, to connect them with appropriate services as early as possible to pursue a potential pathway to legal immigration status. So that is just a quick summary of our state laws and policies on access and supports for immigrant children in the child welfare system to be able to pursue lawful immigration status. Rodrigo is going to talk about how the County of Los Angeles implements these mandates. And yeah, so I'll pass it along. Thank you.
Thanks, Rachel. And with that, we'll pass it over to Rodrigo from LA County to talk about their special immigrant status unit.
Good morning, everybody. Again, my name is Rodrigo Contreras, and I'm the supervisor for the Special Immigrant Status Unit here in DCFS, Los Angeles County. And just to give you a little background, the unit started it started in 1986 with the passage of the Immigration Reform and Control Act. And the idea back then was the county saw that there was a need for a lot of clients who qualified to legalize their status. Although the law intended to deter immigration, it actually helped a lot of immigrant families that were here in the United States illegally. And so the county felt that there was a need to help these clients take advantage of this opportunity. So it was the unit was created, and it became, as is now known, the Special Immigrant Status Unit in 1991 with the passage of SIJS by President George W. Bush. The unit is the only unit of its kind in LA County. We service all of the 19 offices that we have in the county, along with adoptions. I don't have any social workers in the unit. It's comprised of eligibility workers and unit clerks. However, they are very specialized, and they know everything that they need to know about the SIJS. We have our own policy within LA County. We work very closely with the children's attorneys to identify as many children as possible to make sure that the children take advantage of the SIJS. However, it is the unit staff that creates the SIJS finding orders and submit them to the attorneys for filing with the court, so that then the children can be qualified as special immigrant juvenile. But there's many times when we have found that the court orders social workers to make a referral to our unit. However, as you have heard with the previous speakers, there's specific requirements that they need to have in order for the children to qualify. So although sometimes the court may order a social worker to make a referral to our unit, if the client does not qualify, unfortunately, there's really not much that we can do. And of course, as you remember, children who qualify for SIJS they need to be dependents of the court. They need to have a no reunification order with at least one of the parents. They need to be for us, it needs to be under the age of 21. However, we would rather get them before the age of 18, because then we can get orders from the court that allows us to then refer the client to an attorney and provide the attorney with all of the documents. We do not, as mentioned before, all of the services that we offer within the unit. The unit, the way it was created, because at the time it really took 6 months to get a green card or permanent resident card. That changed about 7 years ago, And prior to 7 years ago, the unit used to file everything with the court. I mean, with immigration, with the USCIS. And again, we were able to get the green cards within 6 months. However, when that changed, the county felt that there was a need to move away from the unit doing all of the paperwork, because we saw that we were getting a lot of requests for evidence, denials, or intents to deny. And so at that time, the county felt, you know what, this may become a liability later on. So let's hire attorneys to do it. At the time when we entered into a contract about 5 years ago with with an agency here in LA County, we had about 400 cases, 375 cases that were pending. That's more or less when the backlog started. And so when we entered into a contract with the attorneys, we send them all of the cases. So we send them so many cases to the point where we actually um, uh, overwhelmed them with with all of the work that we had. So at this point, we work with our contract agency. There's also other agencies that have received grants to assist children, and so we also connect with them to continue referring our SIJS cases. Again, we don't do any of the paperwork any longer, and so we refer the clients to the attorneys. However, the unit will continue to work with the attorney until there is a resolution. So if it takes 5 years, the unit will continue to be a middle person, so that if the attorney needs to get in contact with the client, we will go ahead and look into our records and make sure that we find all of the information to locate clients. As you may know, um, once it's getting closer for the clients to get their green card, they need to get fingerprints done, and they need to get a medical exam. So at that time, we're able to connect again with the client to make sure that they follow through, in order to avoid USCIS denying their application because they didn't comply with everything that they needed to do. Um, Many times our clients come with immigration proceedings already in place. So we request the social workers to please let us know as soon as they find out that this is going on, because that makes a priority of a case. Because if a client has immigration proceedings, we don't want them to go alone to the attorneys, I mean to immigration court. And we want to make sure that they are connected with an attorney to approve, to make sure that they get the services necessary. So that's basically what we do with SIJS. However, we also do U visas, VAWA, T visas. There's 3 certifiers within the county for U visas. I'm the one that mainly signs on them. And as you may know, a U visa is not a residency, legal residency. However, it can lead to it. But we also review all of our records to ensure that that the client qualifies, that the client is connected with an attorney, and also that they fully cooperated with the department in the investigation. Again, we work with T visas. So we certify the visas. Other services that the unit provides are replacement and renewals of green cards. For those clients whom we process the initial residency cards, many times if they're under the age of 21, we're able to pay for the fees if they don't qualify for a fee waiver. Once they become eligible to be to become citizens, we also connect them with an attorney, and we will help any client within the county, except that if we didn't process their initial green cards, unfortunately, we're not able to pay for the renewal, replacement, or citizenship if they don't qualify for a fee waiver. As mentioned in previous presentations, the birth certificate is very important. And so we have created excellent relationships with the consulates of El Salvador, Mexico, Honduras, and Guatemala. And so we're able to connect with them. Most of our clients, fortunately, come from those countries. And so we're able to locate those birth certificates. We have also been able to make relationships with other consulates. We're in the process of working out birth certificates for the Philippines. We have been able to get information on how to obtain birth certificates, although we have not been successful. But at least they provided information from the Chinese consulate. We have been able to get certificates from Colombia and other places that have been helpful to us. That's about it. Within the LA County, just one more thing, sorry. Within the LA County, for those clients who don't qualify for any others of our services, we provide the number for an office within LA County that's called the Office of Immigrant Affairs. They help clients, immigrant clients, connect with various social services, including protection, consumer protection, mental health, health services. So if there's any clients within LA County that don't qualify for any of the services that our unit provides, we request that the social workers provide the number for the Office of Immigrant Affairs so they can get an assessment by an attorney, which includes obviously legal assistance whenever they need it. And that's about it.
Great, thank you, Rodrigo. And now we're going to pivot to New York City to hear from Boyana about the Immigrant Services and Language Affairs program within the NYC Administration for Children's Services.
Thank you, Sophia. Yes, we are from the New York City Administration for Children's Services. Next slide, please. Just a quick background of where the program is. We are part of the ACS Division of External Affairs, and our program has basically two arms. One is about language access, and the other is immigration. And I, of course, will be telling you about immigration today. Next slide. Just a little more about what exactly we do, how we function within the Administration for Children's Services is that as you can see, we're in charge of the agency policies. We provide a lot of training for our staff and our contracted providers. We have a program that's specifically focused on immigration services for youth in care. That's the one that I manage. And we do lots of case-by-case consultations, and we also certify UNT visas, and we do community work for immigrant clients. I'll tell you all about it on the coming slides. Next one, please. We always like to begin by reminding everybody that, New York City, more than 1/3 of New Yorkers are immigrants. They're foreign born. Also very important information for us, the important stats are that more than half of New York City's children live in the household with at least one foreign born family member. And we also, since the work we do is on language access, we have some data about almost 1/4 of New Yorkers not being limited English proficient, not being able to speak or write English well, which is almost half of New York City's immigrants. Next slide, please. So ACS, Administration for Children's Services, has a policy on special immigrant juvenile status and immigration assistance. And it basically, it's not just about children who are undocumented and would qualify for SIDGE, but also for any child or young person in care who is not a US citizen. They need to be identified. We need to know that they don't have US citizenship status. And then we go through the steps that I will describe to refer them for immigration services. Next slide, please. So yes, it always takes a village. We can move on. And in this case, it consists of a collaborative team that I will describe each of these parties in detail. Next slide, please. So we are the hub of this effort. We are the Immigration Services for Youth in Care. We oversee foster care agencies. The ACS is contracted with 25 foster care providers. And then with other collaborative partners, we do lots of trainings, lots of presentations. We will do individual case-by-case consultation. And we also track and keep records of the progress of these cases of all children in ACS care who have immigration needs, because we also have to provide annual reports to the New York City government. Next slide, please. The divisions that the ACS structure that is involved in here, it's pretty, most of the divisions such as family court legal services, those are the ACS attorneys who represent ACS in family court, family permanency, that is a foster care division. And then of course, we have any other division where, young person, there can be a lot of intersection with different parts of ACS, and they all will be involved if the case requires that. Next slide, please. This is very important, and this is a particular benefit we have in New York City, and we are very happy about us. We have, we don't have in-house immigration attorneys. We work with the public service immigration attorneys in the city, the various organizations such as Legal Aid Society, At the Door, Safe Passage. There are various, and they represent our, we refer children to them. We don't refer children to any immigration attorney, but to this group of approved providers. They have a special expertise in representing not just immigrant clients, but also immigrant clients who are also involved with family court. And they are also great advocates for our children. They work pro bono for us, and ACS covers the cost of any of the government fees, of course, that come with these applications. Next slide, please. And then the foster care, that was the last circle on that collaborative team. Like I say, we contract with currently 25 different foster care providers. So what are their responsibility towards immigrant children and youth in their care? They have to appoint an immigration liaison, and that's our point person. That our office works with that person, and that person also is their in-house expert. We help to train and assist the immigration liaison. They are tasked with screening all children and youth in their care to determine who is not U.S. citizen, and then make a referral with our guidance and while keeping us involved to the immigration attorney. As you know, the process of getting someone immigration status is lengthy. So foster care agencies and case planning teams in foster care agencies are expected to continue this collaboration with immigration attorneys and with our program to support the young person. And because these young people, as they get older, sometimes get impatient and don't understand why they have to wait another year or 2 or 3 to get their status. And also we require that all foster care providers record, track, and report to us quarterly the status of immigrant children and youth in their agencies, the progress of their immigration assistance. Next slide, please. We also help, ACS because, not all the clients that ACS work with, are involved in foster care, but there are also families and children not in care. So our office is there to support ACS teams and the clients who need assistance. Usually, mostly, it's SIJ can be a person can be eligible for SIJ even if they are not in care. And also our office certifies U visas and T visa requests that are submitted by the attorneys of our clients. Next slide, please. And we generally provide guidance to our staff and all contracted providers about how to work with immigrant clients. We do lots of trainings about, the unique challenges that immigrant clients experience, the fear, the reservations that they have working with any kind of government agency, the use of appropriate terminology when you work with clients or when you put records in the system, the importance of not communicating with immigration authorities, not without an immigration attorney. And then we also share resources. We gather and share the resources with the providers or what is available in New York City for immigrants. As you know, the city is overwhelmed right now with more recent arrivals of mostly asylum seekers, but not everybody is an asylum seeker. So the city does have resources, but those can be overwhelmed, not always easy to find. So we try to facilitate also that for our staff to be able to guide our clients to those resources. And next slide, please. And that's it. This is where you can find contact information for the program director, my supervisor, Lauren McSwain. This is me. And there is a general email for a mailbox that if you have any questions for us. And I think that's within my 8 minutes. Thank you.
Thank you, Bojana. And finally, we're going to end in New Mexico, and we're going to hear from Megan Fino Velasquez about the immigration unit within New Mexico's Children, Youth, and Families Department.
Hey, good morning, everyone. Thanks for having me. I was not actually the scheduled presenter for this. Our immigration specialist, Yolanda Castro de Esquivel, was supposed to be here, but she's ill. So I probably won't have as many details to offer as she will, but I can do my best here. So if you'd like to go on to the next slide. So I was part of the leadership team in New Mexico that designed this unit, which was implemented in 2019. And what the unit was designed to do was essentially all things related to immigration and any international or transnational work in support of the Child Welfare Agency, the Children, Youth, and Families Department. So it's a small unit that supports the entire state, and it's comprised of 4 positions, manager or director kind of position, an immigration attorney in-house, and 2 immigration specialists, one of whom supports casework in child protective services, and the other one that supports casework in juvenile justice related cases as well. So in general, the unit provides consultation on all cases involving immigrant children or youth or families. So even if a child is US born and a child is a US citizen, we flag all of the cases that may involve a primary caregiver or parent who is not a US citizen, to assess how that may be impacting the case in some way. This unit is also responsible for consular notification requirements, that serves as the liaison to foreign countries' consulates as well, and does all the communicating on behalf of the department with the foreign countries' consulates. We also provide facilitation of all services in foreign countries. We assist with communicating to relatives in other countries as well. And so oftentimes, what the unit does is it provides staffings with caseworkers in the field on a regular basis to provide all sorts of support on cases, whether it's meeting with parents or family members in other countries to help with engagement, whether it's facilitating visits with children, whether it's connecting people with legal resources and supports. This unit's responsible for all of it. The unit is also responsible for some initial eligibility screening for immigration relief. And there is an immigration attorney position, which does some of the initial screeners for when it's believed that a child or a youth is not a US citizen. And then in most cases, the immigration attorney or the immigration specialist at this point will refer then a child out for legal services to one of our legal immigration organizations, one of our legal organizations that have a contract with the state to provide ongoing legal consult and representation on things like U visas, T visas, SIJS, defensive deportation, those types of things for our children and youth in care. Let's see, this unit in general also provides translation services. Again, we do, or the unit has provided representation for children. Specifically, the immigration attorney has provided representation on a very limited case-by-case basis for children and youth in our care, only on SIJS matters and only in cases in which the child is expected to stay in the custody of the department for a long period of time, if that's what it looks like. But most often we provide referrals for immigration legal assistance for children to some of the legal immigration providers. We have active contracts for them to provide ongoing representation for our children. And these legal immigration providers are also able to provide consults to other family members. So they can provide legal consults for children and youth, for their family members, for parents who may be facing deportation or stuck in other countries. They can provide legal consults for youth who are involved with the juvenile justice system and their family members to provide assistance and legal advice on how that might impact their status, et cetera. The unit also provides consultation and is responsible for the federal reporting of potential victims of human trafficking. And what the unit also does is provide extensive staff training and staff support in immigration related issues. So as Randi was talking about earlier, for the special immigrant juvenile status, for getting the kinds of orders that need to be to be got. Our immigration attorney position is the one that provides ongoing support to our children's court attorneys, or the attorneys that actually represent the department on the cases, in order to help ensure that they're getting the right court orders, basically, for the matters. And let's see. Yeah, I think that's about all I need to say on that. And so the way the process actually works for Child Protective Services is that our unit, the Immigration Affairs Unit, coordinates the initial meeting with our case staff upon receiving notification that there's a non-citizen minor in custody. And then the unit arranges and coordinates a screening meeting with our immigration attorney, with case staff, also with the guardian ad litem or the youth attorney or the child or youth when appropriate, with appropriate releases of information, depending on the child's age. And then based on that initial screening, decisions are made about, whether a child or youth might qualify and how to, and who should be appropriately representing them on cases. And then throughout the life of the case, while a child is in child welfare custody, the unit continues to have monthly meetings and staffings with all parties involved throughout the life of the legal case to provide ongoing updates in terms of how it works. And on our juvenile justice side, we also coordinate an immigration screening meeting with an immigration attorney, with a juvenile probation officer, and with a youth, if the youth themselves is an immigrant. And then the unit also connects a youth attorney with a public defender who is contracted throughout the state to provide an immigration analysis of each case, just so that each youth is and their attorney is aware of any potential immigration consequences to how they plea, et cetera, et cetera. So next slide. I think there's not much more that I have to add about this, except that our immigration unit directly manages contracts with a few main providers in New Mexico. Our kind of nonprofit legal immigration providers are New Mexico Immigrant Law Center and Santa Fe Dreamers Project are the big ones in the state. And we contract with them to represent all the children and youth who need assistance, who are involved with the department. And we also work very closely with our Mexican consulates in case there are other family members who may have legal immigration matters that are impacting their involvement with our case at all. Most of the families, the majority of the families who we talk with here in New Mexico who are involved with the state are of Mexican origin. And so with our close relationship with the Mexican consulate, the consulate is often able to connect family members to all other legal assistance if they are in need of it as well. And then we also have a few other community-based immigration attorneys that help us in a very kind of limited basis, depending on the nature of the case. So that's the model here. And I think that's all I'll say about that. Thank you.
Thanks, Megan. And a huge thank you to all of the panelists who joined us today to talk about the models in their states. In the last few minutes that we have today, we are going to take a few minutes to highlight some helpful resources on the topics that we covered today. So if you are interested in learning more in depth about some of the specific models we talked about today, there are a couple of publications out there that you can refer to. This first one, the Pathway to Permanency article, describes the New Jersey model that we heard about today from Randi and Georgiana. The middle resource is from the CICW. We published a guide that documents the model utilized in Mexico that Megan, in New Mexico, that Megan just talked about. And then we also just recently, as in last week, published this third resource on serving immigrant children and families with child welfare system involvement. And it's essentially a guide or a report that documents the models from many of the jurisdictions that we heard about today, and including a few additional ones. And so it goes into a lot of the pieces that are needed to provide equitable care to children and immigrant families who touch the child welfare system. So that's also now available on our website. I'm going to paste the links to these in the chat in just a moment. And then you can also find them via this QR code on a page on our website that has kind of some curated resources related to serving immigrant children and families in the child welfare system. So give me just a second, I will paste these in the chat, and then I'll move on to the next slide of resources. So here are just a few additional comprehensive resources. The MPI Migration Policy Institute report highlights 9 key policy and practice recommendations for child welfare agencies with respect to serving immigrant youth and families. It also has a section that specifically discusses screening youth for immigration benefits, if you're interested in learning more about that. The Immigrant Legal Resource Center also has a guide on strengthening child welfare practice for immigrant children and families in California. That also has a section on immigration relief. And a lot of the practices discussed in this report may also be applicable to other places. They also have a webpage with various different relevant resources pertaining to immigrant youth, including many resources on SIJS. And we will send all of these resources to folks in a follow-up email after the webinar as well. Let me paste these resources in the chat for you. Okay, and then finally, the CICW also coordinates an immigration and child welfare practice network, which includes child welfare agency representatives who work with families around immigration issues across the country. We convene on a quarterly basis to share policy updates and discuss common challenges and best practice. We also distribute a monthly e-newsletter in which we highlight various types of resources related to immigration and child welfare issues, including upcoming training or webinar opportunities, news articles, and new practice policy and research pieces. And you can sign up for both of these opportunities on our website, and I will paste the direct links in the chat. And with that, we can open it up for questions. It looks like the majority of questions that have been submitted throughout the duration of the webinar have been answered already. It looks like we have one additional question. If one of our panelists wants to take this one, the question is, how long does it take for the U visa approval for victims of trafficking, domestic violence, and serious crimes? So I don't know if there's one of our panelists who wants to answer that question. I'm going to stop sharing.
When you say approval, is that for the final process of getting the permanent resident card, or just the initial approval so they can then continue with the process?
I don't have any further context for this question. I don't know if the participant's able to enter any additional.
I have heard that the final decision to get the actual green card, it can take up to 10 years. But after 3 years, a client, about 3 years, what I have heard, again, from our attorneys, after 3 years, they may be able to apply for a work permit while they wait for the green card.
Okay, thanks, Rodrigo. Are there any other questions from any attendees? Please feel free to enter them in the Q&A section at this time.
I'll just follow up with that. Can everybody hear me?
Sure.
So I'm Rachel Conrad. I'm an immigration attorney with Casey Family Programs. The T visa process, the first step in the process is the trafficking victim certification letter with OTIP. And while it can sometimes take that long for the person to be eligible for a green card, in order for the child to get the work permit and the social security number, it's not necessary that they apply for the green card at the same time. So I would say, and I don't know if Randi, if you have dealt with this more recently than I have in direct practice, but I haven't seen it taking that long on like the technical, at least in my information on the technical assistance and the systems improvement side. It seems that the certification letter through the Child Protection Unit can come through much faster.
So I think the question was about U visas, not T visas. I'm not
Oh,
sure.
I'm sorry, I got confused then. I
but,
agree. The backlog for you is terrible.
The U visa, you know, I think Rodrigo was actually being kind. I think it's more like 5 years to get the approval and 10 plus now to get the green, you know, but it is a great tool because, you know, the youth can put all family members as derivatives, so it's a real family unity. The T visas were really fast and they're getting a little slower now. So, you know, it can take now up to 2 years. But they can be, there are some grounds for expediting. But they're, you know, they don't have the backlog that SIDG has. So we've been trying to lean on the T's a little more lately where we can, where we have.
Yeah, my apologies for confusing it. Yes, use, if you have a case that you think is U, screen it for T at the same time to figure out if T might be a faster avenue or, but even with U, when they're waiting for their U, can't they get the work permit under a well, no, they're not deferred action. Isn't there eligibility to apply for a work
but
permit?
that's what's taking 3 to 5 years.
Yeah.
So, but then they can get that while they wait. Yes, for the U visa.
Okay.
So there's another question. I have some youth who have unknowingly applied for asylum. First, are they able to switch over to SIDG to avoid getting denied asylum? So the answer to that is, you know, if they are SIDG eligible, yes. And in fact, you know, in many instances, we initially will apply for more than one form of immigration relief, just to give the child or youth the best chance of getting on a path to lawful permanent resident status. Of course, we also will have a counseling session or more than one with the child or youth to, you know, talk about the benefits and consequences of different forms of relief. But we will sometimes apply for more than one, and when one comes through, we may withdraw the other. It is very possible. I have many clients who I have applied for SIDG and asylum almost simultaneous. Yes, you can apply for more than one. At some point, and it will depend on the circumstances, one will need to be withdrawn. And just so everyone understands, I mean, for a child who has obtained lawful permanent resident status through a SIDG, they will never be able to sponsor their parent, even a non-offending parent. So that is sometimes a concern for the child. But with asylum, they will not be able to return in most instances to their country of origin. So that is also sometimes a concern to a child who may want to go back and see a grandmother or a parent these are the kinds of things that lawyers will discuss with the clients in determining the different forms of immigration relief that the child might be eligible for and the consequences.
Thanks, Randy. And Boyana, this question might be for you. I think the question here is whether the services that you described in New York City are just for New York City.
Well, yes, we cover only the children. This is what I described is for children who are in the custody of the city. They reside in the 5 boroughs, or at least the foster care providers are registered in the 5 boroughs. So what they described is what the case is for the city. I cannot speak to other parts of New York State.
And it looks like those are all the questions that we have received from our attendees. So with that, I think we can give everyone 5 minutes back this Monday morning to get an extra cup of coffee or whatever that might be. Again, a huge thank you to all of our panelists this morning. And we will share out a recording of this webinar and all of the resources that were shared. And we can also share out contact info, I think, for our panelists if you're needing to follow up with them for more information or specific questions about things. Thank you for joining us and have a good rest of your day.